Well, hi there, and welcome back to another episode of Let's Talk Real Estate Investing. I'm your host, Sharon Vornholt, and I'm so happy you're tuning in today. I have another reader question for you, and it's a good one. We're going to talk about what happens when someone passes away in your rental property. So here we go. The exact question was, when a tenant passes away in your rental property and they have a month-to-month lease with no one else on the lease, how long do you give the family to clean out the house? And she went on to say he was there for 15 years and he had a lot of stuff. She also goes on to say that they inherited the tenant when they bought the house. And what a great question. So I want to cut this one down into bite-sized pieces. And so that if you come into this situation yourself, you'll know what to do. If you find yourself in a situation where someone has passed away in your property and you are the one that finds them, then this is a simple answer. You're going to want to notify the authorities. Call the police and let them and the coroner handle that one, because there are a whole set of things that have to happen around that one. But we're going to assume that if you are told about the death of someone that rents your property, maybe from a family member or a friend, and they know that they live there. So they walk into your office or they call you on the phone and they want to get into the place and, just dive in and start taking things out. Well, first of all, you're going to need written documentation of the death. Now, this could either be from the family, it could be from a friend, it could be from anyone. And this would be no matter which way you happen to find them in the property or you were notified that they had passed away. And this written documentation is a death notice. Now that could be an obituary put out by the family. It could be in the form of something about a service put out by the funeral home. But regardless of that, number one, you know that the person renting from you has indeed passed away. But secondly, you have to wait for the information on the executor or the personal representative. In probate, they have very strict rules about who can get in, who is in charge, and how the belongings will be disposed of. And your job as a property manager or landlord is to secure the property as soon as you know that someone has passed away. You cannot let anyone in the property until you have all this information. And believe me, they will often try to get in. They'll be the favorite son, the favorite daughter, the mother, but it's not for you to decide. There are probate laws, as I said, that determine the handling of this, and you don't want to get in trouble as a property manager by doing this the wrong way. No one can just go in and remove belongings until you're certain of the legal status of this situation. You will want to work with the executor or the personal representative, or in some cases, it might be a probate attorney or a court, to be sure that you are in legal compliance with everything that you have to do. Now, if they bring you, let's say that a family member brings you paperwork that says they are the administrator or the executor, also known as the personal representative jointly. So if they bring you paperwork that says that they have been declared by the court to be the person, I call them the decision maker, the person that's in charge of handling this estate, then you can move forward and you can give them the key. But until you have that paperwork, you don't know who you can and cannot legally allow into the property. So you want to be sure that you don't allow anyone into the property, regardless of how big of a fuss they put up. And that does happen. You just have to say simply that your legal department or your attorney or whoever you want to say has a process in place for you to be sure that you are meeting the legal requirements of your state. Just keep it very generic, but know that you just can't go off and handle this any way that you want to handle it. You're going to need to work with the executor in some cases. As I said, in some cases, it might be an attorney or the court. And big shout out to my real estate attorney, who always has the answer to me, and that's Harry Borders here in Louisville. I would call Harry if I had any questions about the legality of anything, and he would always say, this is the way you do it. So better to err on the side of caution than to get in trouble. Now, as a landlord, your number one priority will always be to regain control of the property as soon as possible. But you must be mindful while you're following the law, and you might want to know that you've got to pack your patience during this process. If there has to be a court proceeding that sets all of this in place, then it's going to take a little while. So know that this is a process. Now let's move on to the lease. The lease that the tenant had with you extends to the expiration of the date, even if the tenant passes away. Now, if it's a month-to-month lease, once you receive official written notice of the tenant's death, this acts as a 30-day notice and signals the end of the lease. So you need that written notice, but you also need the proof, the paperwork that says who's in charge, who can legally enter the property, who has been appointed the administrator or named in the will as the executor. And this can cause quite a delay if the people are not motivated to move fast, but you need these things. So on a month-to-month lease, that's a 30-day notice. Now, this also puts the estate, the executor, whoever's in charge, in the position of paying that 30 days rent to you. So that would be a reason that they would want to move this along quickly. The fact that they don't want to pay to get this out of their own pocket for the lease. So you can move forward in that way. Now, if it's a long-term lease, the tenant's estate is legally required and responsible to pay the lease until it expires. This would be out of the proceeds of the estate. But in reality, most landlords, most property managers just want to get their property back. They just want to get possession of the property and re-rent it. So in most cases, the landlords will work with you. Now, you might ask, what about the security deposit? And that's something a lot of people ask about. The security deposit in this case is like in any other case in that it can be used to cover damages, back rent, and any other outstanding cost. But any unused portion of that security deposit cannot be kept by you. It must be returned to the executor or to the person in charge of the estate. That would there's not going to be, depending on where your property is, you may or may not have a portion of the security deposit left over. Because if you have to get into cleaning out the property, that's going to be a cost to you. And it may be that if you manage for instance, a large apartment community, you might have staff where they're already getting a paycheck, so it wouldn't be an issue. If you're a small landlord and you have to hire someone, then that's going to be a cost to you if you had to do that. Now, if the amount of the repairs or the money owed exceeds the cost of the security deposit, the way you go about that is to try to work with the executor and see if you can work something out. If you cannot work something out that works for both of you, then you're going to have to file a claim against the estate if there is a probate. That's a big if. Now, I've talked before about the notice to creditors, which is published in almost every state. I know New York does not publish a notice to creditors, and there may be one that I don't know about. But by and large, there will be a notice to creditors, and that is to let people know that the estate has been opened, and this is a step in that process, the notice to creditors, so that if a creditor has any money that is owed to them, this is the time and this is how they would get paid. If your property happens to be an apartment community, or really it could be the same for a rental house, that person may not have enough in assets to even warrant going through probate. So if there's no probate, you really don't have a lot of recourse. So know the laws in your area, know the rules and the regulations, and don't get yourself into hot water. I hope that answers the question, and thanks to Dawn for this insightful question. If you want to learn more about probate investing, you can do that on the blog, the Louisville Gals Real Estate blog. You can listen to this podcast for other episodes, Let's Talk Real Estate Investing podcast. I also have a freebie called the Probate Investing Starter Kit. And you can get that at a link I'll put in the show notes, but it's probateinvestingsimplified.com/starter kit. It's completely free and it will give you everything you need to just get started working in the niche of probates. And don't forget to check out my probate investing course. If you want to dig deeper, if you want to dive deeper and learn how to build a profitable probate investing business, which by the way, you should be doing given the situation we're in with the baby boomers, you can check that out at probateinvestingsimplified.com. Okay, I hope you found this tip valuable. This was a great question. As always, feel free to send in your questions to Sharon at SharonVornholt.com. I will see you same time, same place next week. Bye for now.